Thank the Minister. That concludes questions for oral answer. I have received a letter from Carmel Sepuloni seeking to debate under Standing Order 389 the release of the report by the Independent Police Conduct Authority regarding the so-called Roastbusters case. In order for an urgent debate to be held, there must be a particular case of recent occurrence involving ministerial responsibility. The report was released this afternoon. It finds a number of significant deficiencies in the original police investigation into the alleged offending. This matter has been the subject of 2 earlier applications, those related to the decision not to prosecute, for which there is no ministerial responsibility. However, at the time I indicated that if the Independent Police Complaints Authority report was to reveal a significant development, the matter may warrant the setting aside of the business of the House. The authority has found that the victims were let down by the failure of the police to identify a connection between the cases and work with other agencies to develop strategies to reduce reoccurrence of what was clearly unacceptable and in some cases alleged criminal behaviour. Having again considered the matter and having read the report today, I have determined that the House should debate this matter. It is of critical importance that the public have confidence in the ability of the police to investigate. I call on Carmel Sepuloni to move that the House take note of a matter of urgent public business.
Mr Speaker, I move on behalf of Carmel Sepuloni that the House take note of urgent
Jacinda
business.
Ardern.
Thank you, Mr Speaker. Mr Speaker, it's devastating to say that there is only one way to describe the report that was released by the Independent Police Conduct Authority at midday today, and that word is damning. 1 year on from a thorough investigation that started under the IPCA in November of 2013, we have a report that clearly demonstrates a failure to follow through adequately the complaints that were raised by not one, by not two, but by several young women that documented abhorrent behaviour against them. It shows that there was a failure to consider all of the options around prosecution, which directly contradicts some of the later police investigation. It shows a failure to even properly record the personal information of the alleged offenders. It shows a failure to consider alternate options, if indeed prosecution was not one of those options, by the police in terms of holding those alleged offenders to account. And it shows a failure to even communicate adequately and properly between the number of different police officers who were involved in this case. This report shows that these young women were absolutely the subject of a failed process. There is no question, Mr Speaker, and we should all be absolutely alarmed and concerned that that has been the case. Mr Speaker, I think it would be helpful to go back to the beginning just to cover off what led to the situation of the House conducting an urgent debate today. I will then go on to cover some of the specific and most concerning elements of this report. At the end of 2013, Mr Speaker, there were a series of disturbing stories that became public in the media, which related to what can only be described as abhorrent behaviour by a group of young women against a group of vulnerable young women and girls. I want to highlight that. Some of these young women were merely children at the time that some of these events took place. We were all disturbed by what we heard and saw in the media, and of course we expected that there would be an opportunity for swift response and action by the police. That was the public expectation, Mr Speaker. Now, we know that there are always layers to these issues, so of course it was incumbent on the police to, as much as they could, share with us, share with the public what they had done to work alongside those victims. The police response was to state that there had been no formal complaints and therefore they did not have sufficient evidence to pursue an investigation. I want to reiterate that with a quote that went into the public domain from the police. They issued a statement which stated, quote, "In the absence of significant evidence, such as formal statements, there is not enough evidence to prosecute the alleged offenders at this time." The public, of course, were severely disappointed that there wasn't, therefore, from the police's perspective, the ability to pursue what we all agreed was abhorrent behaviour. The minister even came out publicly and implored that those who were involved in this case, the victims in this case, that they be brave. That was the statement that the minister used in the public domain, that they be brave. Now, Mr. Speaker, putting aside the fact that it shouldn't have to be incumbent on any victim to have to be brave to go through a criminal justice process to have justice done. That should not take bravery, Mr. Speaker. Our young woman in particular should have been well enough supported that it wouldn't take courage to endure our system, and yet that was the words used by the minister. So that in itself raised some significant concerning questions. But leaving that aside, we then within a few days, Mr. Speaker, had a report by TV3 that included another victim coming forward and stating that it was her belief that she had in fact laid a formal complaint, gave a statement, and that nothing was done. Now, of course, we were all alarmed to hear that additional information. Labor was swift to make a complaint to the Independent Police Conduct Authority because questions were raised in our mind. How is it that the police did not know that a formal complaint was made, let alone thoroughly investigate it, given the nature of the offending that was alleged to have happened? I want to quote, Mr. Speaker, from the complaint that Labor made in my name to the Independent Police Conduct Authority at that time. We stated, while all these issues need to be reviewed, there is a wider question of the adequacy of the investigation itself and the decision that there is insufficient evidence to lay charges. In particular, what efforts were made to corroborate the complaints laid by the victims? Was there a full investigation, including the execution of search warrants and particularly electronic surveillance, remembering, Mr. Speaker, how much of this awful situation did occur online? And what advice was received before making the decision not to lay charges? Given the current constraints experienced by the police in terms of resourcing, we would also urge that the authority look at whether this impacted on the child protection team over the 24 months that this investigation has taken place. And finally, we stated, the actions of the local police to protect potential victims while this investigation was underway is also worthy of assessment. The information available in the public domain certainly suggests that intervention via schools and social networks was needed to protect other young women who may have been subject to alleged predatory behaviour. Mr. Speaker, I feel absolutely justified in the fact that Labor made that complaint, and unfortunately this report vindicates it. And I do acknowledge that the Minister of Police laid a similar complaint at the time. But this was not the first report. The first report released by the IPCA looked into the way that the police interacted with the media and the release of information relating to this complaint. I won't dwell on that report, Mr. Speaker, but what it did flag was that there was a complete breakdown in communication between the police officers involved in that complaint, a complete breakdown. And you can see in reading that report that one of the concerns certainly was that the police were absolutely stretched. There were clearly resourcing issues. Now, whilst that does not excuse individual failings towards victims, it does raise massive red flags that I hope that the Minister of Police will pay heed to. And again, it continues to be a concern for us that we have a police force operating with a $40 million budget cut. That does absolutely eventually have consequences, and I fear it has had consequences here. But, Mr. Speaker, as I say, none of that can be an excuse for the way that individuals are treated within a process as serious as this. I want to go through the key elements of the report where there are the most significant concerns that I would like to hear a response from the Minister of Police on. The first is the complete and utter lack of coordination. It is highlighted from the very first paragraphs of this report. Indeed, when the IPCA outline how many cases they were tasked with looking at, they say right up front, at the start of the authorities' investigation in November 2013, it was informed by police that they had received reports of concern about 4 separate incidents. They go on to say, during its investigation into the handling of the complaint, the authority identified that police also responded to 3 other reports of concern involving young women and this same group of young men. The IPCA themselves identified we weren't talking about 4 incidents. We were talking about 7 occurrences where the police had an opportunity to join the dots between a systemic problem, between abhorrent behaviour on multiple occasions involving multiple victims, and it wasn't picked up. Now, of course, regardless of whether it had happened multiple times, each of those individual victims should have got an individual response that should have given them faith in the system. It shouldn't have taken 7 cases to build a case against these young men. But the fact that even that wasn't identified is a massive, massive problem, and one of the key problems identified by the IPCA. Issue number 2, and this goes to the most basic of principles, obviously, for the police, and that is whether or not the lines of inquiry were thoroughly followed up, whether or not these complaints were thoroughly investigated. And Mr. Speaker, this is highlighted again by the IPCA, who found that, I want to highlight this one point. This authority has found, and I quote, that all of the police officers involved in these matters treated the young women and their families with courtesy and compassion. We acknowledge that. However, the report goes on to state that because in several of the cases, the officers concluded that there was insufficient evidence to proceed without the cooperation of the young woman, they decided no further action was required. Now, this is an uncomfortable truth. Yes, a few of the young women did not feel comfortable continuing with their complaint, and we need to spend a lot more time debating why that is and what we can do to remedy that. That aside, the IPCA found that the police should have kept going anyway. They should have continued with their investigation and lines of inquiry, and why? Because these were children. In fact, the police's own policy states, all reports of child abuse must be thoroughly investigated, even if the child or young person recants or parents and caregivers are reluctant to continue. That is a quote from the police's own policy on these issues. So whilst the police thought that they were doing the will of the victim, their policy actually required them to take responsibility and continue to investigate, and they didn't. But what was also inadequate about the way that this investigation took place was that they didn't even identify that it was the same young men who were involved. They didn't record properly the information about those young men. They didn't do other inquiries on their police checks to see that other complaints are being made about them. And this is a key point. The IPCA found that if the police had done that, then surely they would have thought about engaging in alternative ways of dealing with this case. If the police decided that the threshold for prosecution hadn't been met, why did they not simply engage in some good old-fashioned policing and go to the homes of those alleged offenders and hold them and their families to account? How is it that complaints like this were being made about these young men, and the first time the police engaged with them was for an inadequate, ill-prepared, ill-considered interview, and that was it? Now, I might be old-fashioned, but I would wager that I'm not alone in the public in saying the police should have knocked on those young men's door. Regardless if they were there to put handcuffs on them, they should have questioned them on their behaviour, they should have told their family about what was going on, they should have done everything in their power to stop further victims from being put through the situation that these 7 young women were, simply by confronting their behaviour, and that didn't happen. Mr. Speaker, probably one of the most significant other findings of the report was the question as to whether or not everything was considered in terms of the ability to prosecute these offenders. I want to read from the report because this is particularly important. They considered whether or not sexual conduct with a young person under 16, which is section 134 of the Crimes Act, was properly considered by the police as an option for prosecution. They state, under section 134 of the Crimes Act, everyone who has a sexual connection with or does an indecent act on a young person has committed an offence. There is no question that these young men were aware that the young women involved in the 6 cases were under 16 years. There is no question. The authority recognises that it is uncommon for police to prosecute a young person under section 134 for sexual connection with a person of the same or similar age. It is clear that this general thinking underpinned the approach taken by the officers in these cases. The authority does not accept the validity of this reasoning, as there are a number of aggravating features in this case that should have prompted consideration of such a prosecution. In our view, the fact that the parties are close together in age, while a relevant factor, is not determinative. The reality is that a prosecution under section 134 also says nothing about the presence or absence of consent, because it is simply irrelevant to the facts that need to be proved. What needs to be proved is age. And as the report points out, these young men involved in this case absolutely knew these young women were underage. The report finds that the police should have at least discussed this option with the victims. Mr. Speaker, it is clear that the failings in this report were significant. The police have a lot to do if they want to give security to victims in the future, that they will handle these complaints adequately.
The member's time has expired. The Honourable Michael Woodhouse.